Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about debt collection lawsuits. They are on the rise, and I'm not just saying that to just be saying it. They are on the rise. We have an influx again this week after the holidays of people being sued. I have one gentleman who is being sued by 4 different collection agencies contacted me yesterday. Now, let me just tell you, number one, we got to get into the right mindset. If we're going to deal with these types of problems, dealing with debt collectors, dealing with our credit, dealing with things that can kind of make us not feel too good, we have to reverse it and we have to feel good about ourselves. We have to understand that what we're going through with our debt, what we're going through with our credit, that's a part of something that is external. The pieces that you have full control, or the part that you have full control, is your thinking, is your body, is the way you feel. You got to make yourself, you got to manipulate. If you don't feel good, you got to manipulate yourself to make you feel good. There are days that I walk into my office and I'll come in here and I'll start clapping. I'm happy to be here, number one, for myself, for what I've achieved for myself and my family, that I'm doing exactly what I wanted to do in my life, and I'm helping people like you. But even before I get to work, I do what I call, and I got to say it the way I say it. I know people say, well, Steve, get right to the topic. We're going to get to the topic about talking about debt collection lawsuits and how you can win debt collection lawsuits. But I got to do my stuff the way I do it. When I get up in the morning, I call it, you got to wake up 2 times. First, you get up and your body is getting up, and sometimes you can struggle out of bed. I pop out of bed. My wife be like, how do you pop out of bed? But even if I don't pop out of bed the way that I popped out of bed the day before or whatever, you got to wake yourself up 2 times. The first time is your body is waking up. The second time is get your mind off of automatic. Because when you were sleeping, and especially if you got debt and credit issues, and you sleeping on it, you going to sleep worrying about the debt collector. What are they going to do tomorrow? What are they going to do? That court date is coming up. Like every day, that court date, it was like 20, 30 days away or 2 months away. And every day that you wake up, that date is getting closer. And deep down inside, you may not express it on the outside, but deep down inside, you got to do something. You got to do something. Maybe you haven't even shared what's going on with your spouse. Yesterday, I spoke with a young lady where her husband didn't even tell her that they were being sued, and all of a sudden, his paycheck was being garnished. That's when she got the bad news. And I'm here to tell you, I'm not like these other professionals that'll be like, oh, why did you do that? Why did you hide that from your spouse? All of that stuff. Because, see, this is the difference. I've talked about it in other videos. And we are going to get to talking about debt collection lawsuits and how you can win debt collection lawsuits. And I'm actually going to quote one of the cases that's going to help you out. But stick with me, because if it was all about the book and giving you the knowledge, stuff would be solved like that. There's plenty of videos and lawyers and everybody out there and people who teach stuff. If the body does not get flowing, if your body doesn't feel like doing anything, if your mind doesn't allow you to feel like doing anything, you won't do it. You will just avoid the pain. So the things what we got to do is, when we're facing stuff like this, is we got to get our body in action. We got to get our mind thinking a different way of solutions, of that good things can happen, and get out of that poor thinking mindset. And so to get back to, I'm not like other professionals, is I went through stuff like this. It's the difference between a coach who is coaching a team that has never played on the field and a coach who is coaching the team who has played on the field. I've went through this stuff. And still to this day, but there are people coming to me now that has more debt than I had, but most of it is business debt. But to this day, I still have not ran into anyone who had the amount of personal debt that I had. I had $300,000 in personal debt in 1994 after building a successful business and doing what most of us do, which is start buying stuff. It took us from 1994 to 1999, me and my wife, to work our way out of that. And the strategies that I talk about in my videos is exactly what we use, and it's even better now because I got more experience, I got more knowledge, and even also additionally to that, because that is important, knowledge and experience is very important, but I've put it into action and tested it. So I understand that you want stuff to calm down. You want stuff to get back to normal. You don't want these flare-ups. You don't want to be putting out these fires. You don't want to be fighting with your spouse. You want certainty in your life. And I'm here to tell you, as your friend, as your mentor, as someone that you can look at and put comments, and you know that I have had the same feelings that you might have with dealing with debt collectors and credit issues, that I know what you're going through and that you want to get stuff back to normal. So let's get right into it. How do we beat debt collectors? We can beat debt collectors. And when I say we, that means you and I, we can beat debt collectors. But first, I want to tell you something. If you avoid, evade, don't show up, don't respond to the debt collection court summons, you are putting yourself in a bad situation. Now, let me tell you some of the stuff that can happen if you do not respond or show up and have some sort of response to that court summons or citation, whatever they want to call it in your area. Because this stuff, you got to take it serious. I'm seeing so many people losing money that they should not have to lose. So if that could get you moving in the right direction, is that there are people out there, and this was also something that the ACLU reported on, and this is something that one of the judicial trade groups reported on, that a large percentage, over 90% of the debt collection lawsuits, the documentation, the debt collector didn't even have enough documentation to prove the case, but because people didn't challenge them on it, they won those cases either by default judgment, or even if the individual showed up there, they still won the case because people don't know how to challenge them. And let me say one other thing before I get into this here. I'm just going to go ahead and say it. I'm not going to mention any names or no company or any companies. But what I am going to say is that when you could win your case if you set up your defense immediately when you respond to the court summons. There are attorneys out there, and I'm not an attorney, and I'm not giving you legal advice. I'm just telling you what has worked and gotten cases upwards. The highest one recently, and I played the video audio on it, $100,000 case dismissed. There are softwares that are out there that people can pay and have their court summons response created. There are attorneys that are out there that create responses, and everybody is telling people, except for me, to deny everything. The prevailing thought process is you don't want to put out a defense until you the debt collector decides to move forward with the case after your deny response thing, or whatever, what everybody is telling everybody to do. Me being counterintuitive, which means that why wait and prolong things? Why not let the debt collector know what the hell you are going to challenge them on, so they can make a determination if they want to move forward? And when I put that into action and started testing it, guess what happened? Instead of waiting for hearing number 1 and then go to hearing number 2 and potentially hearing number 3, debt collectors started dismissing the cases before it even got to the first hearing. They started dismissing the cases because they were going to be challenged. And we'll get into how they're going to be challenged. Please like this video, post your questions and comments. This is Stephen A. Williams, president and founder of the creditrepairshop.com. We're talking about in this video how to beat debt collectors, but we're going to also talk about the consequences of if you do not respond to the debt collector when they're suing you in court. First thing that could happen is you could get a default judgment. And you don't want that. If you get a default judgment against you, you're going to open up the door for them to do wage garnishments. You're going to open up the door for them to do bank account levies. You're going to open up the door for them to be able to freeze your money in your account. Now, what's the difference? Wage garnishment, self-explanatory. If you're a W-2 worker, they can send it to your employer, a writ of garnishment, an order from the judge saying they want to garnish your wages up to 25% per pay period. This is something that people don't think about until it happens. Is that they're like thinking it's going to be something monthly. If we're not talking about every pay period that you have, they're going to take that money out. And then people start to say, well, don't they care about my expenses? In a roundabout way, they do care about your expenses, but you're going to have to prove that information. They're not going to just go off of what you say. So a remedy, if you're running into where you're being garnished, you can reach out and you can say, can we do a financial workup so I can show you that the amount that you're garnishing me for is putting me in a bad situation, and I may not be able to pay any of my bills, which is going to put me in a bankruptcy situation. But you could say that all day, but they want to see that in writing because someone is going to have to make a decision on if they're going to lower your garnishment. Now, you should also always look for exemptions for garnishment. Now, if you have exemptions, that does not mean that the debt is going to go away necessarily. Sometimes it could be forgiven in a 1099-C if they feel that your situation is just not going to work. Maybe you're disabled, something, military veteran, PTSD, stuff like that. They could potentially just say, we're going to just cease and just forgive the debt. They can do that. And for all of you who say, watch out if they send it to the IRS, because that's what they're going to do, a 1099-C to the IRS, you got to pay taxes on that forgiven amount. But there's an IRS waiver form. You can look it up yourself. IRS waiver form. You'll see the form, insolvency form. Forgive me. IRS insolvency waiver form. And you'll see you won't even have to pay any taxes on that. You can say thank you to President Obama 2008 for the housing crisis. They put that into law. So if you can get it reduced, you can see if you have exemptions. If you don't make enough money, like in my state, if you don't make enough money, there is a baseline where they just cannot garnish you, but it does not make the debt go away. You're going to have to resolve that at some period of time, because we're talking about moving forward. We can't move forward with having debt and stuff that's just lingering behind us. It's going to make it very hard. It's like pulling a weight. When you're trying to move forward, you got a weight behind you. And you also, if it's a judgment, it's behind you. If it's debt collection, it's over your head, because it could come slamming down on you any day and put you into this situation where you're going to have to be dragging that until you can resolve it. If you do not get a W-2 paycheck, you're not working for someone, you're a contractor, they can levy your bank account or freeze your bank account. The difference between a levy and a freeze, I've seen freezes when there was a default judgment. The judge sometimes does not feel good about allowing the money to just be taken out because it was a default judgment where the individual did not show up in court. So then you'll have it frozen. You can't access your money. You can't do anything to pay your bills unless you go into court, and you have to fill out the forms to be able to at least have get to a certain amount of your money to pay your expenses. And that is law in all 50 states. But you have to do the paperwork to get to that point. If you did go to court and you got a judgment and they do garnish your bank account, they could take all of your money. They could take all of your money until it's paid. Every paycheck, they're going to be like the first one with their handout, and the bank is going to give it to them. Your remedy for that is you got to still go to court, and you have to, number one, if it's a husband-wife situation, if it was only one of the spouses that was being sued, half of the money can't even be touched. And then out of the money that can be touched, you can go into court and you can let the court know what your expenses are, and then they will give money back. They will actually have to give money back and have to work out a deal with you. But this all has to be done in court with documents. And that's what that's what makes people procrastinate. Because they are like, hey, I don't want to even have to go to court and do this. I don't know if they're going to listen to me. I don't know what to do. I don't know what to say. Well, the way to avoid that is to do what I'm telling you to do, with not forgetting to respond or not procrastinate to respond to the court summons. Because when you don't respond to the court summons, you're putting yourself in that situation, making it worse. It's like a bad domino effect. Like, you're not just going to be dealing with the debt collector, you're going to be dealing with your other stuff that you've been paying on timely. It's going to mess up that stuff. The other things that can happen is they can put property liens, and they can also, in some situations, they can take assets from you. And also, if they get the judgment, another thing that is not really talked about too much is that they can actually keep increasing that until you pay it. That they actually get to have, every state has an interest rate charge that they're allowed to charge on a yearly basis, and it could be a high interest rate, and so you could see your debt ballooning up. You can see it ballooning up. So now let's talk about the ways that we can beat debt collectors, so we don't sit there and either prolong things or play this tennis match with them. Let's put some stuff right in front of their face so they can know, because they know the problems with their case. They know. But see, they got so comfortable. It's like a boxer who was always knocking out people, and then when someone came to knock them out that actually wanted to fight hard against them, number one, at the beginning, it was easy to knock them out. Like when we started doing this, left and right, we were getting dismissals left and right. And then they started making adjustments, but still there's problems with their cases. So we're going to talk about one here. It was insufficient documentation. One of the most common reasons why debt collectors lose cases is due to insufficient documentation to prove the debt. For instance, in Green versus Portfolio Recovery Associates, debt collectors failed to provide adequate proof of ownership of the debt. They could not establish a clear chain of title from the original creditor to themselves, leading to the loss in court. I've talked about this over and over and over and over and over again. See, just think about this. If you have a debt collector who is suing you in court, and you straight up from the beginning put that in your affirmative defense that they have not given a full proof of chain of custody, they know that they got problems with their case. They know, but they don't expect you to ask those questions. So what you would do, the easiest way to do it, and this video could be 3 hours long if I told you what we go through at looking at documents. When we talk to people about sending in the documents so we can review them, it's because we're doing a full audit of those documents to see the problems. The problem can be right there in front of your face, but if you don't understand how to look at these documents, you're not going to know. And they'll be in there in court like, man, we got away with this one too. So you look at the documents and you want to look at the full chain of ownership. You want to look at the they call it a conformity statement that shows how it came from the original creditor over to the debt collector. Now, there's other problems in between that. Even if they have those documents, there's still problems. We've seen problems where the dates didn't match, where they said that they bought it on one date, then they amended it and had it on another date, and the person didn't even, the individual that they were suing, the account wasn't even charged off at that time period. So it's like they're just trying to amend documents to make it look right, and with them lying about the way that they're amending the documents, they're messing up their case on another side. That's why you got to look at all of the documents. Other problems that we've seen is where it says that the portfolio is not 100% accurate. So what part of the portfolio that you just purchased from the original creditor is not accurate? You can't just come into I mean, just think about this. You're picking up your car. I'm going to use an analogy with this. You're picking up your car. They just fixed the problem that you had with the engine, and they give it back to you and say, part of what we fixed, we cannot guarantee. That's the same thing that they're saying, just in another way. We just bought this whole portfolio of debt for pennies on the dollar, and inside of the contract that we had with the original creditor, it states that part of this, we cannot guarantee all of it to be accurate. What part is not accurate? What part is accurate? No names on there. Nothing is in detail. They're just making a statement. So you got to look at all of your documents. You look at everything. Put it on a table. Get your coffee ready. Like I got mine. Let me take a quick drink. Get your coffee ready, or your tea ready, or your water ready, whatever you drink, Gatorade, whatever it is. Don't drink too much sugar though, because that can make you get sleepy. And just look at the documents once. Just the first time, go through it, let the shock run through you. Second time, go through it and start getting your body, remember what I talked about earlier, get your body moving in the right direction, like we're going to win. Third time, go through and start combing through and looking at every piece. Looking at every piece for potential problems. Look for stuff that don't sound right first to you. If it doesn't sound right to you, then you start to do research on that specific issue that doesn't sound right to you. And then you will, using that information, you'll be able to build your affirmative defense on that one issue. When we build them out, we could have 9, 10, 11, 12, depending on the case, the affirmative defense issues, that affirmative defense is based on the documentation that they provided, which would be an issue for their side of the case. Other things that have been, that debt collectors have, that have allowed debt collectors to lose their cases, other issues that they ran into were false statements and misrepresentations. Debt collectors can lose their cases if they make statements or misrepresentations about the debt. You won't know that unless you look at the documentation. The Consumer Financial Protection Bureau highlights cases where debt collectors misrepresented the amount owed or legal status of the debt, such as claiming that you could be sued for debt that was already discharged in bankruptcy. Debt collectors, in a recent case, a debt collector made a claim that they could sue an individual for debt that was in bankruptcy, and then they tried to come back around and say, oh, we didn't know that they were in bankruptcy. when they got phone conversations showing that they knew that they were in bankruptcy. Other issues that debt collectors have ran into when suing people and have uh, and has made them lose their case in court is violation of the Fair Debt Collections Practices Act. Debt collectors may also lose their cases if they violate the FDCPA. Common violations include harassment. Let me define harassment. They can't say things like, oh, you should pay your bills, or why don't you pay your bills, or you should be an upstanding person and pay your bills. That is harassment according to the Fair Debt Collection Practices Act. Using deceptive practices like saying that you owe a certain amount, or sending documents like these affidavits to give an impression as if they work for the company that they bought the debt from, when all they did is looked at the documents, the same documents that they gave you that could be false and misleading, and did and swore to those documents. They did not go into the original creditor's office and look at all of the documents in their accounting records and know 100% that those documents are accurate. They did not do that. That's deceptive practices in my estimation. And then failing to validate the debt upon the request when requested by the debtor. I want to speak on that also, is that if you're being sued by a debt collector and you send a debt validation to the debt collector, that is, you're doing the right thing, but you're doing it in the wrong order. You do a debt validation directly to the debt collector when they send you that 30-day letter. But if you are being sued by the debt collector, then you must put in your affirmative defense your debt validation request to make them prove the debt. The CFPB has taken enforcement action against numerous debt collectors for such violations, ensuring they are held accountable for illegal practices by not doing debt validations. And then another thing is the failure to comply with legal procedures. Another reason debt collectors lose is failing to comply with proper legal procedures, such as serving the debtors with the correct legal documents or appearing in court as required. In many instances, debt collectors might not have their paperwork in order. I've talked about that a lot. Having the paperwork in order, their representatives may be unprepared for the hearing, resulting in dismissal of the case. So now this goes back to something that I talked about probably when I first started doing videos on YouTube, and at that time we wasn't really focusing on helping people respond to their court summons. Is that one of the things that I ran into personally when I was going through my debt issues is when I was being sued, I had went to court and I had just started fighting, and I had like everything that I did was on accident, but the attorney that was there for it was for Roush, Sturm, and Hornick at that time, back in the 1990s. They were just getting into buying debt and all that stuff. And but I had noticed that the attorney that they had sent, really, once I started asking questions, was not fully prepared, and they asked for a continuance on the case. And when they came back, it was the head attorney, like Attorney Roush. I was sitting right across the table from Attorney Roush, which is the head name on Roush, Stern and Hornick, which is a national debt collection law firm now. They were just starting here in my state, in Brookfield, Wisconsin. Sat right across from him and went back and forth. At the time, I didn't even know that the debt was past legal statute of limitations to collect, but I knew that I didn't owe $4,500. I knew that I probably at the most owed $500, which is what I negotiated on the debt, $500. So from $4,500 against their top attorney who owns the whole firm, negotiated it down to $500. Went back in front of the judge. Judge said, you must be a good negotiator. You're lucky or whatever. And I was like, I don't believe I owed that amount, and I was going to fight to the end that I didn't owe that amount. I was only 20-something years old, and no one at that time, and that debt was from when I was in the Army, and I got out of the Army when I was 20 years old. So I knew from being 18 years old to 20 years old, I did not have a credit card that was $4,500, because the most amount of money I made when I was in the Army was $1,000 per month. So I knew that that was just false, and probably by me knowing made me more strong to be able to fight and say, I'm not paying y'all $4,500. But what I learned, and when I talk about researching and you look at everything, one of the things that I would have looked at, but it helps me to help you now. So now I want you to like this video, because I'm helping you, and I want you to help other people. And the way that you help other people is liking this video. And what I'm about to tell you is that what I learned and what you will learn by looking at the documents is that it could be past the statute of limitations. That debt that I paid $500 for, I should not have paid anything for. And remember when I said the debt collector will say, boy, we got away with that one. Well, they got away with that one on me, but it was for a lot less than what they expected. But I would not have to have paid any of it if I knew the laws on statute of limitations. And if I knew the laws about the documentation, making sure that all the documentation was in order. So there's a lot of stuff that you got to look at, and the best way to do it is just put it all on the table and comb through it, or you can get it over to us for a free review, and we'll let you know your options on that. So going to end the video here. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video, What Makes Us Different, so you can see my 8-point validation process and my 2-phase settlement process. You need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports, and all 3 scores. If you have debt collectors coming after you early in the game, early, not if they're suing you, early, like they're sending you the debt collection letter, grab my 3-pack of letters: statute of limitations, debt validation, cease, desist, collection activities letter. Use the one appropriate for your situation. I do ask for a donation on those, because those can save you time, money, and frustration. And I really appreciate it. It shows me that you appreciate me taking the time to help you with your situation. If you have debt collectors suing you in court, go to my website, thecreditrepairshop.com, upload your court summons for review. We'll follow up with you. Put your phone number in there too. Some of the times we have to go back and forth to get the individual's phone numbers. Or if it's the file, you can't get it up there, you could send it to us at our email, and you can go to the website to grab that. Please post your questions and comments. Subscribe to the channel. Like this video. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com. Have a great day.